Hello, my name is Peter Bricks. I'm a bankruptcy attorney for debtors in the Northern District of Georgia, specializing in Chapter 7 and Chapter 13 bankruptcy. I have offices in Dunwoody and Jonesboro, Georgia. Before we get started, I want to read you this quick disclaimer. We are a debt relief agency, proudly assisting consumers in filing bankruptcy. There is no attorney-client relationship with the viewer of this message unless there's a fee agreement. We would have to meet with you individually to offer you applicable and accurate legal advice. This message should be used only for informational purposes. Today we're going to talk about a question of do both spouses need to file bankruptcy together? If you're married, is it possible that only you can file and your spouse can not file? The answer to that question is yes, and in fact, there are a lot of times where you both don't want to file. You rather it's more beneficial to only have one of you file. I've had a typical scenario this plays out, and I've seen it play out with me several times. Debtor and spouse are about to be foreclosed, so they want to file bankruptcy to stop the foreclosure sale. They want to file the Chapter 13 bankruptcy, which is the repayment plan, so that way they can pay off the arrears, get caught up on the mortgage, make the ongoing payment, and that's their plan. And really, they're both on the note, both on the mortgage, they're both on the title to the house. Okay, and then in this scenario, we've also seen that there's really the issue is the mortgage. And there's not a lot of credit card debt, or if there is credit card debt, it's only in one spouse's name. So what you have here is a situation where if either spouse were to file bankruptcy, they're both on title, remember. So if either spouse were to file bankruptcy, they get the protection of the automatic stay that stops the foreclosure. That's true whether they both file or either spouse files. And then what you have is, even if only one spouse files and the other one is on the mortgage, the one spouse who's filing has to devise a payment plan to pay off all the arrears. What that means is the mortgage debt is going to be paid off, so the other non-filing spouse would be protected in that sense. Additionally, the non-filing spouse might have maybe minimal credit card debt or no credit card debt, or even, let's say, joint debt. If the non-filing spouse has no credit card debt, then that's not a problem. But let's say the non-filing spouse has credit card debt exclusively in that non-filing spouse's name. That non-filing spouse can pay that by what's called the marital deduction on your means test, which is, let's say the non-filing spouse is bringing in $4,000 take-home pay, but he really needs to devote $500 of that to pay off the credit card bills in his name, even if that's just covering the minimum payments. Then that spouse can do that, can take that deduction, so that it only contributes $3,500 to the filing spouse. So the filing spouse only has that much when they're devising their repayment plan. Now, there are other complicating factors there. The spouse might need more money because the arrears could be so high, but let's just pretend that's not an issue. Then what you have is the non-filing spouse being able to pay off their debts outside bankruptcy, the filing spouse being able to pay off their debts within the bankruptcy, and all is accomplished. The only reason the case was filed at that time was to stop the foreclosure. So that was accomplished, and then what you have here is the non-filing spouse, that spouse deciding not to file didn't really impact the household. The household got what they wanted. They stopped the foreclosure. They came up with the repayment plan. So now the non-filing spouse doesn't have a bankruptcy on their credit. Who knows, maybe they're running their own business and they're going to need to be out there applying for credit, which is a limitation once you've got a bankruptcy on your record. So that's one of the things you want to examine. There are other. We talked earlier about the fact there could be joint debts. So let's say the filing spouse wants to pay 0% on their unsecured debts, but they do have a joint debt with their non-filing spouse. To protect the non-filing spouse, essentially say, well, you shouldn't have to come into bankruptcy just because of this debt, this credit card debt. They could apply to treat that that creditor as a, quote, special class of unsecured creditors and pay it at 100% to protect the non-filing spouse. Yes, that could draw objections, but that would be at least the debtor's goal in filing just by themselves and without the other spouse. So there are other complicating factors. Also, I'm in Georgia. We're not a community property state, but there are community property states where maybe the assets, the amount of the assets could factor in, because unsecured creditors are paid in part by the amount of assets you take into a case. So typically you would find that what you really have to examine is either spouse, is the way the title of the house is that going to enable either spouse to file bankruptcy and stop the foreclosure? That's kind of the first examination. Then the second examination is what is the nature of the debts? Are there joint debts? Well, that would possibly lead to a joint filing, but it depends how much joint debts. And then the other part is, even if there are no joint debts, they still might want a joint file if, say, one spouse has $50,000 in his name, the other spouse has $50,000 just in her name. The debts might be so high that that one doesn't want to say, hey, I don't want to file and I'll deal with my $50,000 outside bankruptcy. That might just be too much. So this is absolutely not to say there aren't times where the spouses should file together. This really is to say that you shouldn't just make the gut reaction and assume that you both need to file together, because you might determine that it really only one spouse filing is pretty much going to accomplish all the goals anyway. So that covers spouses filing together or filing individually in Chapter 7, Chapter 13 bankruptcy.